Good afternoon. Yesterday we discussed about law and jurisprudence. Today I intend to discuss with you about law and justice. If you recall from the yesterday's lecture, we discussed about the very concept of law, how law is being defined, how law has evolved over the period of time, and what are the different schools of law which tells us about different understanding of law and jurisprudence. Well, today let us look at what law is from Indian context more particularly. That means what are the sources of law when it comes to our country in India. Now, when you say the sources, primarily from Indian context, we find four important sources of law. Number one is the Constitution of India. Number two are the customs. Number three are the legislation. And number four are the precedents. Now, let us take the first one, that's the Constitution. As you all know, the Constitution is the mother of all laws in the country. A particular law or the legislation can be proved to be or can be declared as otherwise the Constitution if it violates or infringes on any of the rights being enshrined in the Constitution. And that remains the supreme law of the land. Anything that's being enacted by the legislature has to be in conformity with the Constitution of India. Now, the customs. Is customary law? Yes, custom has been declared to be law by Article 13(3)(a) of the Constitution of India, which says that law includes customs too. Now, if we take the example of Assam and various other northeastern countries, we find that there is a provision in the Constitution, that is the sixth schedule of the Constitution, which says that certain customary practices or the tribal areas are to be protected from the safe enforcement of any other law. That what I mean to say here is that the customs which govern some of the tribal areas in Assam and Northeast are being given protection by the Constitution also. And customs are, in fact, I would say it came before the society as an organization came into being. Somebody, Sarmah has in fact said that custom is to society what law is to state. Is the expression and realization to the measure of man's insight and ability of the principle of right and justice. That means what custom is for society, the same thing is law for the state. It has been established, or it is basically an established uses having the force of law. The point I'm trying to deliberate before you here is that custom is also a law. It has been declared to be a law by the Indian Constitution, and it has been established by law, and it has got all the ingredients of law. But the controversy remains that whether custom should be codified or uncodified. There's one particular school of thinking which says that customs should be codified, but the other school says that if customs are codified, the beauty of customs get defeated. That's primarily the cultural studies point of view, that customs should be allowed to remain as custom. That is how we can retain the beauty of customs. Coming to the next source of law, that is the legislation. When it comes to legislation, we have two varieties of legislation in India. One is the supreme legislation and the other is the subordinate legislation. What is the supreme legislation? Now, as the very name implies, legislation is something which is being enacted by the houses of the parliament or by the houses of the state assembly. Something what we call a statute. To call something a statute, it has to be passed by either houses of parliament or at the state level by the houses of state assembly. Now we have different varieties of statutes or the legislation in India. Say for instance, we have the Juvenile Justice Act, we have the Copyright Act, we have the Information Technology Act. All these laws, at some point of the time or the other, were enacted by the legislature, and that's why we call them statute. But there's something called delegated or the subordinate legislation also. That is, when something is not being made by the legislature per se, but they have delegated the powers of that legislation to say for instance, to the bureaucracy, or to in a university set up, say for instance, the board of management or the academic council or other authorities have certain powers to make laws, and the laws which are being made by such bodies, authorized bodies by the parliament, authorized bodies by the statutes, are called primarily the legislation. The next is the precedent. As the very name implies, precedent is something which has been decided by the court. Because as far as the common law countries are concerned, India is also a common law country. Anything being decided by the Supreme Court is binding on all the courts in India. But the interesting fact is that it is not binding on the Supreme Court itself. That means if on a particular point of law, the Supreme Court has given a particular judgment, while deciding a similar case by the High Court of any state for that matter, the High Court has to take into account, or the High Court is bound to, by the way the Supreme Court has decided on the matter. And when we talk about the precedent, there are three important things that we need to note here. One is the doctrine of stare decisis, second is the ratio decidendi, and third is the obiter dicta. Let me explain to you what is the meaning of these three important terminologies. Number one is the doctrine of stare decisis. Now, stare decisis implies to stand by things decided, or to abide by former precedent where the same point come again. I have already told you about that if something is being decided by the Supreme Court by virtue of Article 141 of the Constitution, the High Courts are bound by that. But the Supreme Court itself is not bound by it. So that means on a similar facts and circumstances, the courts are bound by what has been decided. The next important component of the sources of law is ratio decidendi. What is that ratio decidendi? Now, ratio decidendi implies the material facts of a case plus decision thereon, that is the rule or reason upon which the decision is founded. That means the court may not follow a precedent in entirety, that means in totality, but what the court are bound by. In certain cases, the way a particular judgment was arrived at, and on the factual metrics of that, if a particular judgment was delivered, that particular point of law is something which is binding on all the courts in India. The third important thing, obiter dicta. Now, what is that? Is something not binding on the courts of India, but it is primarily the observation being made by court in a particular case. Statement of law made by a court which goes beyond the requirements of a particular case are obiter dicta. That means the third important component is, it's not something that is binding on the court, but court do take into account the important observation being made by a court on similar facts and circumstances. After having discussed to you about the sources of law in India, let us look at what are the types of law in India. Now, when it comes to types of law, there are four important types of law. One is the common law, second is the civil law, third is the criminal law, and fourth is the statutory law. The number one is the common law. as the very name implies. It is a body of law derived from judicial decisions of courts and similar tribunals. The defining characteristics of common law is that it arises as a precedent. I have already discussed to you about the precedent, and that means in Indian context, it is not the constitution or the laws being framed by the legislature, but also the decisions being pronounced by the Supreme Court, which is considered as law, which is one of the law. That is what I mean to say, that one type, that is the common law. Now, common law can be traced back to have its origin in England. It came to India along with the infiltration of British East India Company. The universal consent and practice of the people from time immemorial formed the basis of common law. In nutshell, what I can convey to you here is that the decisions of the superior courts are important law. They are one of the important types of law as far as India is concerned, as far as the common law countries are concerned. Number two is the civil law. The civil law primarily, the law which is used or law which is applied for the purpose of adjudication of civil disputes, which are primarily in India, law of contracts, family law, law of torts, and property law. That means for the adjudication of justice pertaining to civil matters, the civil law or the sets of civil law, civil legislations are used. Next, the criminal law. We know of the Indian Penal Code, we know of the Code of Criminal Procedure, we know of the Evidence Act. Now, these three important laws form the core of the criminal law in India, apart from, I repeat, the various special and local laws being enacted for the purpose of addressing offenses from time to time are, it is the criminal law in Indian context. Now, one of the interesting facts about the criminal law is that when it comes to this branch of law, you don't have to go to it. It comes to you automatically whenever somebody happens to commit a crime or an offense. That is the interesting fact about criminal law, and that is why it is one of the very important branches of law which has to do with the rights and liberties of the people. And whenever a crime is being committed, the important thing to be remembered by us is that it is the state which takes cognizance. So is the importance of criminal law. Last but not least, we have statutory laws. Now, what do we mean by statutory laws? As the name implies, statutes. And there's a difference between what is a statute, what is the law, and what is the constitution. I think you have now a fair idea about what is the constitution. Constitution is something that is the mother of all laws. Then you have the statutes. To have a statute, what is important is that it has to be passed by either House of Parliament or by the Assembly. That means all statutes are laws, but not all laws are statutes. When I say it, I also do need to explain to you what is the law. Now, a law can be made not essentially by the House of Parliament or by the State Assembly, but it can also be made by, through the process of delegated legislation, by the executive, or for instance, by any other authorized bodies in the autonomous institution. Different regulations being framed by the government, different orders being passed by the government, different ordinances being framed by the universities. They are laws, but they are not statutes. But what remains to be a statute is the act which was being passed by the parliament or by the state assembly. So these four are the important types of law in India.